guys! This week I got a request from one of you to share my insight on the federal sector appeals process, so that's what we're going to do today. But before we get into it, there are a few things that I need to let you know. First of all, I'm not an attorney. I'm just a federal sector plaintiff who happened to win my case, and I didn't write my appeal all by myself. My attorney did that, with my input. If you have an attorney that you trust, by all means follow their advice during your appeal. This video is for those of us who may not have that. In the federal sector, a lot of us end up having to go through the whole administrative process pro se. And in both sectors, there are employment attorneys out there who rely too heavily on boilerplate appeals that just don't work. So personally, I think it's always a good idea to give our attorney our input at every major milestone. I've heard there's some attorneys out there who don't appreciate that kind of thing, but mine never seem to mind. And finally, what I have to say today is focused mostly on the federal sector process. Some of what I have to say will apply in the private sector too. Just know that there are big differences and do your own research. So with all that said, let's get into it. The federal sector process is governed by 29 CFR Part 1614, and there's more detailed guidance in EEOC Management Directive 110, Chapter 9. Now, in federal sector cases, once our administrative judge issues their decision, our agency has 40 days to issue a final agency decision, or FAD, that lays out if and how they plan to implement our AJ's ruling. And we have 30 days after the FAD to file an appeal with EEOC's Office of Federal Operations. Our appeal can include issues from our AJ's decision and the agency's FAD. Now, a lot of us think our appeal is a chance to retry our case and get a better result. But actually, appeals are about pointing out specific factual or legal errors that our judge or agency made in making their decisions. And we also have to focus our arguments on the existing record. We can't introduce any new evidence to try to bolster our case. So how do we get started? I started by listing the parts of my judge's and agency's decisions that seemed illogical or inconsistent with the evidence in my case, and then I asked myself, could this have made a difference in the outcome of my case? And if the answer was yes, that went on my list of potential issues to raise at appeal. For example, my AJ denied my retaliation claim because he said my boss had an honest belief I was AWOL, even though there was no reason for her to believe that. And that never made sense to me. That's just one example that I'm going to use today, but I had a few of these. Next, because our arguments at appeal are supposed to be based on legal or factual errors, well, I framed all my issues in that way, as mistakes. For example, my AJ erred as a matter of law by crediting my supervisor with an honest belief that I was AWOL, even though the record doesn't support that conclusion. Next comes the hard part, substantiating my arguments with case law and citations to the record. Now, there are a lot of places that we can find case law, but my go-to is usually Google Scholar because it's free and easy to use. I searched it for case law related to Title VII retaliation and honest belief by an employer. Then I started with the first case on the list and skimmed through it using the find text function of my browser to look for the parts that were about honest belief. And I kept skimming cases until I either had all the case law that I needed to back up all my arguments, or I had found enough case law to let me know that my arguments weren't going to fly. And let me walk you through an example of how I went about that. The first case Google Scholar gave me here was Majeski versus automatic data processing. Right away, we see that under the honest belief rule, an employer doesn't have to prove that their honest belief was correct, only that it was genuinely held. And we see that comes from the case of Smith versus Chrysler Corporation. That part wasn't exactly encouraging, but let's keep reading. Further down, we see that even though our employer's belief doesn't have to be correct, according to the court in the case of Majeski, employers do have to show that they reasonably relied on the particularized facts that were known at the time they took the adverse action against us. So the question becomes, did my employer do that? Let's take a look at how the court decided that in the Majeski case. Now, Majeski was accused of violating safety procedures. He denied breaking any rules, but his employer claimed that they had an honest belief that he had broken them. And the court determined that his employer's honest belief was reasonable because the company had investigated all the allegations, which indicates that they took them seriously, and also because Majeski had a long history of performance issues. suggesting that he might be prone to making those kinds of mistakes. But in my case, I'm not so sure that my boss reasonably relied on the facts when she decided to accuse me of being AWOL and refuse me reasonable accommodation on that basis. I mean, she verbally accused me of being AWOL that day, but she never documented those concerns, either before that or after. And unlike in the Majeski case, NASA never investigated any of her allegations, which tells me they mustn't have taken them very seriously. And unlike Majeski, I didn't have any prior history of performance or conduct issues, which makes my boss's honest belief seem much less reasonable than in the Majeski case. Next, I decided to look at the source of the honest belief rule that was cited in Majeski, the Smith versus Chrysler case. And of course, that case backs up exactly what was cited in Majeski. That case also directs me to another one that was very helpful to my cause, Pesterfield versus TVA. Now, in this case, the court agreed that an honest belief has to be reasonably supported by facts at the time the adverse action is taken. But it also went a step further and said that even if our employer can show facts that support their honest belief, we plaintiffs should still have the right to rebut that showing with evidence. And that helped me a lot because at my hearing I had actually presented rebuttal evidence, but my AJ apparently ignored that evidence. For example, just a few weeks before my boss first accused me of being AWOL, she had given me a 40-hour time off award. That's a whole week of extra leave. NASA's written policy said that supervisors shouldn't give that award to anyone who had any kind of attendance problems, which makes sense. So that begs the question, if my boss really thought I was AWOL and wasn't at work when I should be, why would she give me more time off and violate agency policy to do it? Doesn't make sense. My AJ just overlooked that. And finally, the Pesterfield case says if an employer doesn't make a reasonably informed and considered decision before taking an adverse action, their whole decision-making process is unworthy of credence, and any belief that was formed through that flawed decision-making process isn't merely questionable, it cannot qualify as an honest belief. That should be plenty to call my boss's honest belief into question. And that means that my AJ made a legal error that should give me a basis for appeal. We can follow similar steps for any arguments that we think might support our appeal. What doesn't make sense about our AJ's or agency's decisions? Would it have made a difference in the outcome of our case? If so, frame it as an error, research the case law, compare it to the facts that are already on the record, and then ask, did my judge apply the case law correctly? And if not, what should they have done instead? And once we've used that process to develop all our legal arguments, there's a very simple template we can use to bring them all together. Now, I'm not going to run through the template in detail, but if you do have questions, drop them in the comments and I'll answer them. And of course, with anything our judge is going to see, we want to be careful of our tone and make sure that we're as clear, concise, and professional as possible. So there you have it, a very quick look at how I would approach my federal sector appeal if I had to do it today. And feel free to adjust my approach and template as you see fit, but this should at least give you a decent start. And if you filed an appeal recently and have any tips of your own to share, please drop them in the comments. I'm still learning too. That's it for today, guys. I'll see you next time. Till then, take care and hang in.